Right, you're on.
Alrighty, I'm on. He says, I feel a little constrained. This thing has tethered me to that, so I like to walk around a little bit. If I trip over the wire, it's Dan's fault. So I'm George Gerken. I know some of the folks in this room. That's Yvonne, just walked in back there. I'm one of the attorneys of the OPBA. Those of you who may or may not know, I'm a retired Toledo police officer, retired in 1997. And I was an attorney at the time, and I've been practicing law for almost 20 years since then. So a lot of my work has been in the area of labor. I represent a lot of the AFSCME folks around here and some policemen periodically, and then I went to work for the OPBA probably 4 or 5 years ago. My departments up here are Wood County, Bowling Green, a few of the other ones, but I don't think I have any the other ones. So anyway, I've been asked to talk to you a little bit about an educational, hopefully, experience on what it means to be sued or charged criminally. That's a really large area, so I'm going to do a little civil procedure here for you. But the very first thing I want to try to do is, hey, Dan, did you talk much about the media?
I did not know.
All right, so if I can get the media part in toward the end, I will. But I'm going to start with the civil procedure class, which everybody in law school hated. But I have right now 3 federal cases going in our northern district, policemen for either excessive force or wrongful death or something like that. And they just don't understand the civil process. I'm going to whiz through this. I'm going to give you some background in some of the things. Typically what you'll find that I can't get up to the podium, Dan. I'm stuck.
Oh.
I don't know. Hey, I'll just stand here. All right, so anyway, the types of cases that you typically get in the civil suits are excessive force, wrongful imprisonment, and then the 2 emotional distress one. Let me ask, has anybody in here ever been sued civilly for an on-the-job thing? How long ago was it?
Sometime in the mid to late 90s.
I'm sorry?
Mid to late 90s.
Mid to late 90s. And who represented you on it?
Nobody, because we weren't a city at that time. Well,
So
the city represented.
The city represented you, and that's one of the things that I want to talk about. When you start looking at a civil case, the city and the OPBA both represent you. It's an important thing for us to do. I'll get into that a little bit later as to why, but the first things I get is, hey, what kind of a chance do they have? And these are the things that we always look at. Were you charged criminally for it? Were you disciplined for it? And were you fired for it? In any civil case involving a police officer on duty, whether it's a sheriff, police, township, or anything like that, you have typically what we call qualified immunity, and that's the threshold. In qualified immunity, and I put on here the state statute, but I'm just going to summarize it for you. Qualified immunity, for the most part, means if you're doing your job within the parameter of your job description and you're not doing anything willful or wanton, then they can't sue you for it civilly. So, let's see. Right there it says the political subdivision. Well, you are part of the political subdivision. It says you're immune from liability if the action or failure to act by the employee involved that which gave rise to the claim. I said powers by virtue of you as a police officer or an employee. So as long as you're a police officer, you get qualified immunity for the most part. However, it has to be something that's not willful and wanton. And I'm going to give you a quick example of what I mean. You may have heard a few years ago there was a case in Cleveland where this lady crawled out of this house, barely dressed, got attention of a passerby, and said, hey, this guy's holding me hostage and he's raping me. And so they went ahead and did a search warrant, and they found 11 dead bodies in this house. Okay? Well, as it turned out, they had arrested the same guy a few years before for a sex crime and a robbery. The detective that interviewed him and investigated the case took it to the prosecutor, the Cuyahoga County prosecutor, and said, look, I don't think I have much here. And so the prosecutor said, okay, well then we'll just release them and not pursue the cases. What the detective didn't tell the prosecutor was there were 4 or 5 leads which could have given them some information that the detective just didn't follow up on. She thought she had it and she was done, so let the guy out. So the families of the people, the 9 victims that were killed subsequent to his arrest and release, sued the city of Cleveland and Cuyahoga County. It's gone through the courts, and I'll go through some of the process a little bit, but what it came down to was there qualified immunity for the detective who did her job? And the court, 8th District out of Cuyahoga County, said no, there isn't. They dismissed everybody else out of the case, the sheriff, the city, probation officers. Everybody else was out but the detective, because they said it was willful and wanton that she really didn't follow up on these things. So what I'm trying to tell you is that even though you have qualified immunity in light of these things, she acted outside the scope of her employment because she was supposed to have investigated it correctly. Indemnification is the next thing that people ask me about is, am I going to have to pay, or do I have to lose my house on this one? And the answer is that even if there's a civil judgment against you, okay, the political subdivision is required by law to actually pay, and there's a specific amount on that, and it's up to $1 million per occurrence. Now that seems like a lot. However, per occurrence could be multiple victims. All right, so you have 2 or 3 people that ended up being shot somewhere. You're way over $1 million right off the bat, because lives are expensive at this point. We just settled one in federal court up here. It was a death and a death case, and there was a question on liability whether, in fact, the medical provider in the county were liable for what happened. And so they valued the case at $1 million, figured it's 50-50 whether a jury would return it, and ended up paying $500,000 for the settlement on a death case. So in that particular case, it was a $1 million case. It's just that there was an issue on some of the things. So I can tell you it doesn't take too long to get to $1 million. If there are punitive damages or anything against you, they don't have to pay that under indemnification. So let's talk about civil procedure real quickly. A complaint, usually you get it in federal court on what they call a 1983 action. It's really 1983, 42 U.S.C. 1983, and it's a deprivation of rights claim. And what this says, if you want to read it, it says, every person who under color of statute or ordinance to anybody else, citizen of the United States or other person within jurisdiction. What this tells you is that you do not have to be a citizen of the United States of America to claim a deprivation of civil rights under this code. It's citizen or any other person. So I get that a lot. Hey, listen, there was an illegal alien came in. You're still liable. We talked about the types of complaints. This is the dual defense strategy that I mentioned earlier. The city, county, political subdivision has the responsibility to defend you. And why is that? Is because they're the ones that are going to be paying generally. So they want to have their people defending you. However, let's say county prosecutor, and the sheriff sued, the county sued, the commissioners are sued, and you're sued. County prosecutor is paid by the commissioners and works with the sheriff. And a lot of times I get things that are slanted toward settlement in their favor. So the OPBA provides you representation on this, and really, we are your attorney. We aren't anybody else's attorney. Their loyalties are divided. So that's why we do this. We generally let the county or the city or whoever it is take the lead on it because they're paying for everything, but we're there for you every step of the way on that. So you file a complaint. the first thing we do is file an answer, and we deny everything in the complaint, okay? Then the next thing we do is we try to file a motion under what we call 12b-6 saying, hey, there isn't anything here, you can't do anything. That never works, all right? Just never works. So we go through discovery and we come to what they call summary judgment. Discovery includes you answering a bunch of questions, us giving them a lot of documents, requests for admission, and then the last one is the thing that's the problem, is the deposition, because that's very expensive. We have to have preparation time. It takes the county and us a lot of time. And then the next one is experts, because they're very expensive. The last one we just did, they figured the expert fees was about $240,000. You guys aren't paying that happily. We're not paying it happily. The political subdivision is. But either way, up to the point where we get to summary judgment, somebody's had to spend a multiple of 6 figures just to get there in almost every case. All right. So what happens is the county, who doesn't want to spend a lot of money, and the plaintiff's attorneys, who don't want to spend a lot of money, always get together ahead of time and say, let's see if we can settle this, either through mediation or just an agreement. I have not had one that has settled that hasn't involved the county paying something. A lot of times they'll just look at the cost of litigation and say it's going to cost us hundreds of thousands of dollars, so we'll throw something at it. My clients come to me and say, I didn't do anything. Why are you paying? I didn't do anything. And so it's a cost-benefit analysis for the county, but it makes you feel really bad because all of a sudden they're paying for something you don't think you did. Not much we can do about that. If they want to pay, they're going to pay. I don't even argue with them. The last couple times it was, the 2 or 3 was well under 50 grand and less because it's still cheaper. But we always make sure that you get dismissed out of the case. And the only one that it shows is paying is the county or the city or something like that. So that gives you a little bit of a comfort, but that's the best we can do. When you go to a trial in a civil case, it's almost always a jury because policemen have pretty good traction with a jury. One of the other things that we had, in fact, we settled one in the Eastern District. We were ready to go to trial, had spent all the money. Sitting there waiting to pick the jury, the magistrate came in for the judge and said, hey, you guys want to take one more shot at doing this because we've analyzed this and there may be enough liability where they would award nominal damages. And nominal damages is like $1. So the jury says, yeah, there's some liability here, but we don't think it's worth anything, so we'll give you $1. All right? Sounds like a win, but it's not, because anytime there's nominal damages award, then there's attorney fees award. And the county was looking at paying $400,000 or $500,000 in attorney fees by that time. So they settled. What can I say? That was a real quick civil liability thing. I don't expect to have a lot of questions, but I'd be happy to answer any. No? Okay, good. We're going to move on to the next one, which is, so that I can find this. I'm good. It's just I don't get to be in the picture. Wow, huh? Let's see. Yeah. Get rid of that one. I don't want that. Alrighty, so criminal liability. This is the one where I get the most questions because it certainly is the one. You can pay money, money's money, but if you're charged criminally and you're found to be guilty criminally, you will suffer a lot more than just money. Anybody here been charged criminally for anything that they've done on duty? No? Okay. One of the other things the OPBDA does is that we give you criminal representation. And I've been all over this state, I'm telling you, representing officers from traffic tickets that they got on duty. One down there in, I don't know, is, just north of Cincinnati, the city cited the county officer for a traffic accident when he was going red light and siren. And we went all the way through that and took it up to Court of Appeals and ended up winning it. But that's the minor things. But normally what you find is that it's almost always excessive force that causes you a problem on these types of criminal cases. The typical type of ones that you get here is assault, aggravated assault, felonious assault, manslaughter, and murder. And a lot of prosecutors try to include a gun spec with it, if you have your gun. Does that seem reasonable to you? Didn't to us either. One of the more famous ones around here was the one in Ottawa Hills where the guy shot the motorcyclist, and he was charged with that. They convicted of him. It had a gun spec on it, and they took it up to the Supreme Court, and the court said you can't charge him with a gun spec while he's a non-duty police officer. But they still try periodically. So anyway, you can also be charged with kidnapping because you're forcibly moving a person from one place to another against their use. Misuse of computers. I get a lot of that supposedly, where guys are doing their own thing on their own on the departments or cities' computers. Theft of services. I think the most recent one I had was guy was having a dalliance with someone in the patrol car while he was working, which doesn't usually go well, and so they charged him theft of services because they weren't paying him to have sex. Simple as that. And then theft, and surprisingly, there's a lot of sex complaints.
What kind of sex complaints?
Yeah.
What kind of sex complaints? Touching. All right, so an officer gets somebody out and frisking them, male to female, something along those lines, or even male to male, and they go beyond what's normally considered to be proprietary, and so they'll go ahead and charge them, and almost always there's some sort of recording of this thing nowadays, and so that's an example of another one. Very few departments will ever do their own investigation. Either they'll bring in BCI or they'll bring in another department to do the investigation. We did one up here where Sandusky County had Lucas County do the investigation for them, and it was a computer thing, misuse of a computer. So almost always they'll get somebody else to do it. So the first thing they want to do is talk to you about it. Hey, Dan went over this morning about the critical incident stuff and Garrity and Miranda and all that other stuff. I don't need to do that. Okay. What happens to you on the job, though, is that they'll either put you on paid administrative leave, which means they'll pay you while they're investigating. But as soon as they really think they got enough, or you get an indictment or a criminal complaint, they'll put you on unpaid administrative leave. Coincidentally, I got one of those exactly same thing yesterday out of Kent, Ohio. Put him on an unpaid administrative leave because he was indicted on something else. So anyway, not much you can do about that. You're all police officers, you've been through this, but I'm going to give you a couple of insights from the criminal defense perspective. Is if they file a complaint, you get a preliminary hearing. Now, in criminal law versus civil law, you don't get to do depositions. In civil, I'll get to bring everybody in, ask them questions under oath, just have a grand time with them, try to flesh everything out. Can't do that in criminal law. I can't bring you in if I'm a criminal defense attorney and you're the investigating officer. Can't even get the witnesses in under a deposition. So a preliminary hearing is really, for a criminal defense attorney, a free deposition of the investigating or arresting officer. We get to ask all sorts of questions with very little harm to our client. Our client never has to testify. You would never have to testify, but we get a lot of information. So it's like a free deposition. Toledo will never give you a preliminary hearing. Perrysburg, other places you do. But most of the time, that's really all it is. Obviously, there's a probable cause threshold. All you have to do is maybe he did it or she did it, and they'll always move it up. So I have one time I've had a court not find probable cause on a preliminary hearing, and surprisingly, it was in federal court a few years ago. So other than that, the next thing is always it goes to the grand jury. If you are charged criminally, I will tell you, I always get the officers say to me, look, I can straighten this out. I want to tell them my story, because you're used to being in charge in there. It's not really a good idea to go to the grand jury if you're a defendant. However, there are exceptions. I had one a couple years ago in Erie County where the officer insisted I'm going to the grand jury, so we went to the grand jury. They recorded his testimony, we got a transcript of it, and he didn't do bad. We'd prepared him. The thing I can't prepare for as far as grand jury goes is the questions you get from the grand jurors. I know what the prosecutor's going to ask, but the questions from the grand jurors, it's like a wild card for us, so we don't know. But he did okay. So we go to trial. 2-week trial. He's charged with felonious assault, aggravated assault, and simple assault, all in generally the same incident. Instead of basically, they can't call him to the stand, the prosecutor, so they played his grand jury statement. I was so happy because there's really no cross-examination in a grand jury. So the prosecutor couldn't put my guy in a stand and cross-examine him and make him look bad. He played his statement, so I never had to put him on. So that's one of the pros of having gone to the grand jury. I get a lot of officers who are in fatal shootings who know they're not going to be charged with this because it was a good shooting, and they say, prosecutor wants me to go to the grand jury just so the grand jurors can hear from me. Get that a lot, don't we? That's a little bit different case. I've kind of let officers go at that point in time if they're serious about it and it's a really good shooting. I don't particularly care, but that's a different case. If you're a defendant, generally I would stay away from it. You know that once you're indicted out of the grand jury, it goes to the common pleas court or somewhere. There's another arraignment, a bond. One of the things I want to talk to you about bond is judges do not like to let police officers who are charged with shootings, murder, felonious assault like that out on OR. They just don't like to do it. It's a political thing, I think. You obviously have ties to the community, you have no criminal history, all that other good stuff, but they just don't like to do it. So you might as well, if you're at that point, figure out you're going to get a cash bond. Discovery, I'm not going to go into a big discovery thing, I'll just tell you that it's now open file versus strict compliance. Almost every prosecutor now open file. They'll just open it up and let you look at it. So that's good for us. It's kind of changed.
It's good for you on the criminal defense side.
Yeah, good for me on the criminal defense side.
Not the file that they're looking at.
Yeah, I mean, I'm just talking as representing you guys on the criminal defense side here. Speedy trial. I get a lot of speedy trial stuff. Anybody know what the speedy trial rule is? No? Come on. Are you just being quiet? Are you awake, everybody? All right, good. You ate lunch. All right. So the speedy trial rule is from the date of arrest, 270 days. All right? You have to be brought to trial unless the time period is told. All right? So if you're in custody, you get 3 for 1, so it's 90 days. You have to have trial. But tolling the time. Temporarily stop from running. What happens? What would toll the time? If I, as your criminal defense attorney, say to you, I need to get discovery. I got to do that. That tolls the time because we're asking for something from them where they have to prepare for it. It tolls the time. If I file a motion to suppress and we have to prepare and hear the motion to suppress, that tolls the time. So everybody that knows there's a speedy trial thing that says, hey, I got to have it within 270 days. It'll be years if it's yours. I hate to say it because policemen just drag on and on and on. Do you try a policeman to a bench trial? Who thinks that's a good or a bad idea? What do you think? Who thinks it's a good idea? Try it to the judge. Come on, no?
I'd say because they did it in Baltimore. When one of the officers, the bench trial.
Mm-hmm.
Was that the acquittal or was that?
The one in Baltimore?
Yeah.
I think it was a reduced charge. I think is the way it ended up. But either way, I will tell you that 99% of the time it's better to go for you guys to a jury trial because people just want to respect policemen and they want to believe you. The one Dan and I did in Erie County, charged him with felonious assault, aggravated assault, and regular assault. And I will tell you, they had a body cam of him beating the heck out of this guy. They had the body cam of him being dragged up to the car all bloody, handcuffed, maced. They had the body cam of him being yanked into the car, okay? And then they had the body cam of him taking the car door and slamming it on the guy's head 7 times. Each time he said, "Get your head in the car." What would you think about that? Now, it just kind of seems that normally when the expert testified that the car door could be a serious a weapon and it could have been serious physical harm, what did the jury do? They acquitted him on the felonious assault, which they should have done. They acquitted him on the aggravated assault, which they should have done. And they were hung for almost a whole day on whether he should have been slamming his head with the car door. Eventually, somebody caved and he was convicted of simple assault. Obviously lost his job, but that just goes to show you, even the things that are obvious, sometimes the jurors won't go along with. 1,100 times a year you find police officers arrested for some sort of crime. Now these are on-duty and off-duty crimes, but they're police officers. And those are the types of charges that you also find, drunk driving, assaults, sex crimes. 72% of the officers charged in cases with known outcomes are convicted, okay? 40% of the crimes were committed on duty, so figure of 1,100, 40% of 72. Officers will be convicted. And unfortunately, most of the people that are charged are men. I hate to say it. The Black Lives Matter and all of the hoopla about police shootings started to run somewhere around 2015 and ran through 2018. These are the folks that generally started this process. And I'm going to kind of talk to you a little bit about each one of those. If you have questions or you want me to stop, feel free, I will. But let me see if I can pull those up.
Fingers crossed.
Okay.
We had some audio-visual problems last week.
Boy, did we.
I think we got yours fixed too.
You know, I could only do so many. I didn't want to get into that one. Let's see. All right, I'm going to have to stand up here a little bit and do this, but the gentleman's name is Savell Smith. The officer is Dominic Hagan Brown. They were in Milwaukee. This video will show you that they started a foot chase, him and another guy. The guy behind him recorded it on his body camera, okay? And I'm going to show it to you. You'll see it at real time. You'll see it at 20% real time, and then we'll talk about it a little bit, and let me see if we can bring it up.
Success.
We'll see. This is the guy behind the officer that shot him. Went pretty quick, didn't it? Okay, here's the slow-mo. Right there, you'll see him pick up a gun and throw it into the backyard. Then you'll see the officer shoot him twice. So let's talk about that a little bit. In real-time speed, it goes really fast. But what they found was, once they looked at the video, is that when the guy was picking up the gun in his hand right here, and he had it about this height when he was starting to throw it, that's when the officer shot him the first time in the arm. Okay? I'm sure he wasn't aiming for the arm, to be honest with you. He just happened to get him in the arm. And then, when Savell fell backwards this way, you can see that his hands in slow-mo are kind of going toward his waist. 1.6 seconds after the first shot in the arm, the officer shot him again in the chest and killed him, right? Basically when he was on his way down. Bam, bam, like that. The officer was, I saw the gun in his hand, I fired, I saw his hand go into his waist, I thought he had another gun, all right? Charged criminally, murder, went to trial. Let's have a vote. Who do you think it was, acquitted or not? How many people think he was acquitted? Yep, me too, because he was. And the idea was, hey, officers have to react. You can't second guess them. As we talked about, you can't do in hindsight. The fact he was going down to his waist, so everybody thought it was fine. Sued civilly. Qualified immunity. So it was just a terrible thing for the officer's life, but honestly, it went on. So this is Philando Castile. This is kind of a troubling one when you watch it. This is in Minnesota, he was stopped for a traffic violation. He tells the officer, I have a gun. The officer says, don't reach for it. Watch what happens. See if I can get the sound on this one here, because you might be able to hear it actually. Hear that? All right.
Where's the volume at? You guys see okay?
Yeah, I can't hear it. Let's see if we can. Well, I'll talk you through it and then we go. Right about now, he is, the sound's really faint on this. Right about now, he says, hey, listen, I have a gun, officer, and the officers tell him, don't reach for it, don't reach for it. And you can see the officer start to stand up, and you can see him put his hand on his hip, and you can see him tell him, keep it away, keep your hand away, don't reach for it. And the next thing you know, you see the officer start to get really nervous. And he's starting to pull his gun halfway out. He sticks his gun in the car and shoots the guy 7 times. Okay? Watch this a little bit, and watch the back door open. I don't know if you noticed or not, but when the guy is pretty casual here walking up, and they're getting the little kid out of the back seat. right in direct line of fire. Fortunately for the kid, nothing happened to him. But the rest of this is thus the aftermath of the shooting. So how do you think this one turned out? Didn't charge him criminally, sued him civilly, found qualified immunity. So he never really faced anything at this point.
So what do you think of that one, George?
I think that one's a lot better than the last one.
What do you mean it was a lot better? That one seemed a little more questionable, I guess.
That one? No, actually, I thought the first, I'm sorry, I thought the first one was a little more questionable. You guys all are taught as far as when you shoot, everything's a double tap for the most part. Bang, 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 2 shots here, 2 shots there, 2 shots there, okay? And so that's generally what the training is on this, and that went back, but he didn't do a double tap on the other one. It was bam, and then he waited again and bam, but doggone, it was so fast. That one was more questionable. This one here, if a guy says, I have a gun, and you tell him don't reach for the gun, and his hand is reaching for the gun in the area of the gun, we had pretty much the same thing up in Findlay, didn't we, Yvonne? There was a gun under the seat. The officer knew it. The guy would not stop reaching for the gun, so the officer shot him once, and that was just fine. So I feel better about that one than I did the other one, to be honest. Yeah, that one.
What about the use of less than lethal force under the circumstances? Could there have been a taser or something else?
Yeah, I don't think you have time. You know, if you're standing there at a traffic stop with your hand on your weapon and he's reaching for a gun, there isn't any, I don't think there's any question about less than lethal force. Go
Is that
ahead.
established case? I've never heard a 2-tap thing before.
What, the double tap?
If that's trained or anything, is that some kind of case established?
OPATA trains you that way. No, you used to anyway, a long time. You guys, anybody else hear about double tap? Yeah, that's it. And honestly, if you do any SWAT training or any of that other stuff, there is always, you know, a vest shoot. So it's 2 to the chest, 1 to the head, that sort of stuff. So anyway, it's just kind of the training that it's inferred that most law enforcement officers have. So Sam DuBose, we're all in Ohio. And we all knew about this University of Cincinnati police officer that shot Sam. And the bottom line here is that Officer Tensing felt he was being dragged and his life was in jeopardy, okay? And so he shot Mr. DuBose, who then went ahead and crashed, and they got him and he died. But it was always in question whether he was being dragged. And so this next clip I'm going to show you is kind of a recreation of that. And the reason I'm doing this is because I want you all to see what can be done with your body cams and how important it is. I mean, if he had not had his body cam on, they probably would have convicted him. But I'll let it kind of speak for itself, and then we'll talk about it later. And I'm going to skip through this because this is a really long, it's like a 30-minute one, and I'm just going to get to a couple of spots that are, I think, really relevant. But anyway, let's see if we can do this one. All right, this is the incident that the body cam caught. That's how fast it was. I'll stop you right there and talk to you a little bit about it. The allegation was when the officer reached in the car to get the keys out of the car. Well, first of all, let me just stop. Is that a good idea? Never a good idea. Reached in the car to get the keys out of the car, okay? The driver locked his arm up against the steering wheel, put the gear shift into drive and started moving forward. Could you tell that from that clip right there? Let me play it again once more and see if you can see any of that. Could you tell that from that clip? Once they go frame by frame, it's pretty evident that something like that happens. Let me get my glasses here and I can find a good spot for you.
So I'd asked the question last week when Joe was talking. Do you think courts are going to start to look at why were you in that situation in the first place, right? Why did you have to reach into the car?
Right.
Why that whole thing could have been avoided had you done something different or tactics or something like that.
It could have been, but it wasn't. Here's a good thing is that this is the video before, this is part of the video before the incident. You can see that they're measuring the steps between the car and the pothole in front of it on the street. And then there's another car up there, and there's a car in the driveway if you look off to the right. In this particular thing, it tells you that the steering wheel's tilted a little bit to the right and why they think that's important. And there's another vehicle up here. And this is the first time, when I went through this, the first time I learned this, but there was a witness to this case. I mean, this incident right here. A witness drove by and saw the whole thing happen and never came forward the whole time. Nobody knows why, and they couldn't figure it out. But you can see that he's trying to open the door to get him out, and Sam is shutting the door, and Officer Tensing is saying, hey, wait a minute. Look at his right hand. Can you see his right hand? What's it doing? According to this, they think it's turning the key in the ignition. So there he is, reaching inside. And there's the guy's pinning his arm up against the steering wheel. They're looking at the SUV in the driveway here, and they're going to do that because they can show the cars moving in relation to the framing of the SUV and the window. Look in the car, you can see the reflection of the officer's legs. And basically what it's showing is that to me, it says he's getting moved forward. So they can tell whether the hand's curled or flat. The next few videos show, or next few slides show you that his hand flattens out, which means he's pulled it back and he's moving it forward. You can see in the one corner where Tenzing's hands reaching forward and is grabbing the seat belt that's going across him there. So the other thing is now they're looking at in a loop. You can see the lines on the pavement have moved from one spot to the other, which shows the car is in motion and his arm's still inside. See his thumb on the top of the slide? I don't know if you noticed or not, but you can figure it out from there. And then the next frame, or the next few slides, will show you where he actually shoots him. That was a big thing, whether he was giving up or not. That's pure speculation, to be honest with you. Just nobody knows that, but that, you know, they had to come up with something, whether he's bracing the seatbelt or not. But one of the things that consistent theme that you get through here is that this car is starting to move at this point while the officer is still inside of it, and that he's actually steering to avoid the car in front of him there. So he shoots him while he's in the car. I'll go through the rest of this, then move on, but shoots him while he's in the car. But the car still drives away. The theory is that he was shot, but his foot was on the accelerator, and it kept on the accelerator until he ran into a tree shortly down the road a little bit here. If anybody ever wants to see the full thing, it's amazing. But one of the things I really want to make sure that you understand is that's the sort of thing you can do with a body cam. Frame by frame by frame analysis, and it's really important for us. This one, I think, probably is the worst shooting you'll see out of all this. You'll only see the last half of this because I edited it out. But what happens is the officer makes a traffic stop. I think it was a license plate. They're sitting in a parking lot. The guy gets out and runs. The officer gets out and chases after him. The officer finds him in a park. All right. At the same time, there's a civilian walking by with a cell phone camera who starts to record the encounter. At the time of the recording, you can see a struggle between the officer and the suspect. And the officer, after he shoots him, says, "Hey, he grabbed my taser." So that's the key is was there an issue on the taser at that point in time? I want you to look at this just fresh one more time, and then we'll see if we can go over it a little quicker than that one. This is the park where the cell phone video is starting. All right, so right there, the headlines were, "Officer shoots black man, unarmed, running away in the back."
Disturbing graphic images captured by Phaeton Santana, 23-year-old Dominican-born barber, simply on his way to work.
As the result of that video and the bad decision made by our officer, he will be charged with murder.
Was an accident. The work that I'm doing in a legal setting.
This guy here is a videographer, a cinematographic videographer, and he took that video and analyzed it. And what he found on that frame was he could see where the taser was out and where the guy was grabbing it. And then he followed it through analysis, frame by frame by frame, where it fell on the ground. Well, why is that important? It's important because later on,
Pixel arrangement of
the
how it's printed.
some of the
I just obsess actually
accusation was in the
crazy. Like you never get that.
like the New York Post that said, hey, the officer planted evidence, because you'll see in the next portion of this, the officer walking up and dropping an object next to the victim on the ground. So he went back and, once again, frame by frame. This is the thing I want to talk to you a little bit about. Anybody familiar with Reddit? Okay, so he posted this stuff on Reddit. And when he posted that he found the frame about the officer planting the thing on the ground, he got thousands of these types of responses, thousands of them. Kill the cop, you got to fry, bad cop, and stuff like that. Well, as you go through this, and you'll see it, almost 5 or 6 seconds later, after the officer drops the taser next to the guy, the officer walks over and picks it up and puts it in his holster. He wasn't planning it. He was just putting it somewhere while he checked the guy. But nobody ever went that. So one of the things that I find interesting is that this guy posted all this new information on Reddit. He got 5 responses. So they're not your friends out there.
I just wanted to know, did he plant a taser? Turns out he didn't. Planted the taser for 30 seconds.
There he is, picking it up and putting it back in his thing.
Had a camera not been there. So why did he plant the taser?
All right. This one is actually still going to trial, and you may recognize it because I think a lot of people have seen it, but I think it's also important This is the latest Chicago shooting. And the officer starts trial, I think it's this month on this one. The last guy, the state jury was a hung jury and couldn't convict him for shooting the guy in the back from 10 yards away. But they took it to federal court, and he ended up having to plead in federal court, and he got 20 years. So anyway, this is Laquan McDonald. This officer, unfortunately, this happened when, right in the height of all the shootings in Chicago. And so what they're doing now is they're responding to a call of a guy breaking into vehicles. And it must have been a slow night in Chicago because we've got quite a response for a guy breaking into vehicles, if you ask me. But either way, we got a bunch of policemen coming to there. You can see them pulling in to the area that was in question. And you can see the spotlight going around, and that guy there is pointing down the street going, he went that way, routine. So you can see him in the back running. So this guy, this video cam kind of takes a detour around there and comes up and catches him running down the street. All right, so as you stop, I want you to see when he walks by the police car and goes to the right, he pulls something out of his pocket and he has it in his hand. And it's a knife. He's got a knife in his hand right there. And he's walking away from the officer, and the officer's telling him, drop it, drop it, drop it. And he didn't, and so he shot him 16 times. He was charged with murder, and he's going to trial on it. I don't know what's going to happen on that one, but you can make your own opinion on that. And then I have one more I want to show you, and I think it's important because everybody wants to know, hey, why are policemen so trigger happy? This guy was stopped. They're giving him field sobriety tests. This is in Pennsylvania. He's not doing all that well on the field sobriety tests, so they're going to try to handcuff him. He takes exception, as you can see. The guy's got his taser out, tased him, and dragged him out of the road. Well, good move. Get him out of the traffic. So it appears he found a gun on him. You can see him taking the gun. He's rendering it safe. The other guy's got his gun on him, and now they're telling him, "Hey, roll over. I want to handcuff you. Cooperate. Don't resist." You can hear "don't resist" a million times on these things, which is the right thing to do. The guy gives him a shot to the common peroneal with his knee. That doesn't work. Now he's punching the heck out of him. It's just not working. The taser didn't work. I think the officers were tired at this point. They just let him run around while he reaches in the car and pulls out a gun and shoots the heck out of him. Shoots that guy right there a bunch of times. Now look at the back window. This is him shooting out the back window at the officers, blowing it out still. And at this point, he drives away. They catch him later, obviously. The officer lived, which was good. But those are the sorts of things that's the sort of video I like to end with, because I don't want you to be afraid to do your job, okay? Because that could end up being you on any traffic stop. Now I know Don's here and it's almost 1:15. Do you want me to do media, or do you want me to just turn it over?
We'll let Don go, and then maybe we'll come back for discussion after.
Okay.
Afterwards.
Okay.
All
right.
You gotta leave at 3 o'clock.
Yeah, about 1:15.
Okay.
Okay.
All right. For the next portion, Don Collins, the General Counsel from the State Employment Relations Board, will be here to give us updates about SERB and the services and things that SERB does for us. So thanks for coming up, Don.
Got some stuff I'm gonna hand out.
Are you going to use your computer next?
Yeah.
All right.
I wanted to tell you, George, one of the lightning video.
On the Chicago case.
I'm sorry, what?
Prosecutor they just rested the case yesterday.
They just what? Rested?
Their case, the
Okay.
prosecution.
I have not had a chance to catch up on that during the week, but so they rested, huh? It'd be interesting. It'd be the defense. And I can pretty much guarantee you that the defense are going to start framing that rule the same way everybody else has, as you've seen, as far as frame by frame shows what it was, what it does, and what it means. I'll just do it as fast as I can.
We can get on the website with that, George.
Pardon?
Yeah, we'll get it. I think we got it working better this time than last time. We're already better off this time.
Very good.
Do you want a microphone?
No, I don't think so. Let me get these handed out here and we can get going. My name is Don Collins, and I am the General Counsel for the State Employment Relations. We're shifting gears here from excessive use of force to labor relations. And I don't know what your backgrounds are, if anyone here sits on the negotiation team, or what your involvement is in the community. What I'm going to talk about this afternoon is sort of what SERB does and what you can use when dealing with labor relations and negotiations. My background, by the way, I worked at the labor employment attorney for the city of Toledo for several years. Then I came down south and went to SERB. I've been there 7 years. My prior life, I was an assistant prosecutor in Franklin County, and one of the things that I worked on were excessive use of force claims by sheriff's deputies at that point in time. So I'm not familiar with shootings per se, but I'm sort of familiar with some of the other